Good morning, guys. My name is Shavin Asthana. I am a second year law student from WIPS IB Delhi and an intern at Lexis & Company. So, today I'll be talking about the topic Section 377. So, you guys might have also known about this topic as you might have studied it in college, and a landmark case judgment was there. So, you guys too might have studied this. That was Navtej Singh Johar versus Union of India. So, let's go back to the history of Section 377. So, Section 377 of the IPC is a section of the Indian Penal Code introduced in 1861 during the British rule of India, modelled on the Burglary Act of 1533, which makes sexual activities against the order of nature illegal. On 6 September 2018, the Supreme Court ruled the application of Section 377 to consensual homosexual sex between adults was unconstitutional, irrational, indefensible, and manifestly arbitrary. So, I'll be talking about the timestamps. Like, for the past 20 years, there has been a battle against Section 377 in India. So basically, in India, a landmark decision by the Supreme Court has finally struck down the 19th century law. The decision follows a protracted struggle by the activists and members of the community against the repressive law introduced in 1861 when India was under British rule. It threatened imprisonment, even a lifetime sentence, and a fine for those who engaged in what it labeled as unnatural offences or intercourse against the order of nature. So let's go back to the timestamps, which goes back to the year 1991, November, December, like the duration between November and December. A document detailing the experiences of gay people in India is released by the AIDS Bhed Bhav Virodhi Andolan (ABVA), an organization fighting discrimination against those affected by HIV or AIDS. The 70-page report reveals the shocking extent of blackmail, extortion, and violence that gay people faced, especially at the hands of the police. The report calls for the repeal of legislation that discriminates against the members of LGBTQ community, including Section 377. But when released at the Press Club of India, journalists are reported so embarrassed they don't raise a single question. And second timestamp is May 1994. Controversy erupts after Kiran Bedi, Inspector General of Tihar Jail, India. You guys might have known Kiran Bedi. She was an IPS and a great woman. So Kiran Bedi, who is the Inspector General of Tihar Jail, refuses to provide condoms for inmates, saying it would encourage homosexuality, besides admitting that inmates indulge in it. In response, ABVA files a writ petition in the Delhi High Court demanding that free condoms be provided and that Section 377 be recognized as unconstitutional. Despite long-running efforts to mobilize support, the petition is eventually dismissed in 2001. So in December 2001, the NAS Foundation, a sexual health NGO working with gay men, files a PIL, that is public interest litigation, in the Delhi High Court challenging the constitutionality of the Section 377 and calling for the legislation of homosexuality. September 2004, the Delhi High Court dismisses the case, saying there is no cause of action and that purely academic issues cannot be examined by the court. A review petition filed by the NAS Foundation is also dismissed a few months later. In February 2006, after the NAS Foundation files a special leave petition for the case, the Supreme Court reinstates it in Delhi High Court, citing that the fact it is an issue of public interest. In the coming months, Voices Against Section 377, a coalition of NGOs, joins the petition, while India's Ministry of Home Affairs files an affidavit against the decriminalization of homosexuality. So in July 2009, in a landmark judgment, a Delhi High Court bench consisting of Chief Justice Ajit Prakash Shah and Justice S. Muralidhar decides to strike down Section 377, saying it violates the fundamental right to life, liberty and equality as enshrined in our constitution. But critics, including Suresh Kumar Kaushal, a Delhi-based astrologer, challenged the Delhi High Court decision in Supreme Court. In December 2013, the LGBTQ community suffers a significant blow when the Supreme Court overturns the Delhi Court's judgment, saying Section 377 does not suffer from the vice of unconstitutionality, and a declaration made by the division bench of the High Court is legally unsustainable. In June 2016, Navtej Singh Johar, an award-winning Bharatanatyam dancer, files a writ petition in the Supreme Court challenging Section 377 along with four high-profile Indians, including Chef Ritu Dalmia and hotelier Amarnath. August 2017, a 9-judge Supreme Court bench hearing petitions against India's biometric program Aadhaar anonymously rules that privacy is a fundamental right. In its judgment, the court also says sexual orientation is an essential attribute of privacy. Discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual, raising the hopes of those campaigning against Section 377. In April 2018, top hotelier Keshav Suri, who identifies as gay, joins the fight, files a petition with the Supreme Court. In July 2018, the five-judge bench of the Supreme Court, including Chief Justice Deepak Misra, begins hearing the petition filed by Johar and others against Section 377. While supporters of the law claim the spread of sexually transmitted disease and the disintegration of India's social fabric as reasons to retain it, many of the justices make encouraging comments. It is not an aberration but a variation, Justice Indu Malhotra says. A central government affidavit leaves the decision on the section's constitutionality to the court's wisdom. The Supreme Court decides to reserve its verdict. In September 2018, in an unanimous verdict, the Supreme Court decides to scrap Section 377, which Chief Justice Misra describes as irrational, indefensible, and manifestly arbitrary, marking a triumph end of a lengthy struggle for justice, decriminalizing homosexuality in India. So I'd like to conclude by saying that the decision made by the bench of 5 judges was a landmark judgment which gives every human being equal rights as defined in our constitution. Thank you.